Do you actually have a court order that orders Mr. Smith to pay child support to Miss Smith?
Yes.
You do? No offense, your interpretation is not the same thing as me reading it specifically.
All right, guys, this courtroom hearing starts off looking like a routine child support case. But within minutes, it becomes painfully clear that something inside the original court order is seriously broken. The judge immediately begins digging through old paperwork while both parents struggle to explain years of confusing legal history. At first, the discussion sounds straightforward: a father paying child support, a mother expecting overdue payments, and the Attorney General's office trying to confirm arrears. But then the judge notices language buried deep inside a 2019 order that changes everything. Listen carefully, because this single wording mistake is about to blow apart the entire case. The court order used the phrase, any child, instead of clearly separating support obligations for each child individually. That tiny wording difference becomes a legal disaster waiting to explode. And once the judge realizes it, the entire courtroom atmosphere shifts from routine paperwork to full-blown damage control over a deeply flawed order.
And it's in the interest of Barry Grace and Matthew Smith. Both parties are now present.
How is Matthew covered with health insurance?
I have Medicaid.
And has Mr. Smith paid you any money directly?
No, ma'am.
Since your last order? Okay. Did you have any safety concerns with your personal information being in this order?
No, ma'am.
I pass this witness, Your Honor. Mr. Smith, where are you working?
I'm working at Excel Mulching in Carthage, Texas. Well, that's where their office is.
How much are you making per hour?
Making $25 an hour.
And how many hours a week do you work?
I've only been working 50 for last month or so. Generally, we work 60 hours, but sometimes, like now, it's just slow, so we're only working 50.
Do you have any health insurance available through your employer?
I'm pretty sure that they offer it, but I haven't been here long enough that they've offered it to me.
How long have you been there?
Getting close to 90 days.
At this time, I asked the court to take judicial notice of the prior order.
The court will take judicial notice of its own file.
Were you working at Excel Mulching at the time of the last order in 2019?
I'm not sure what order that was. That's when they added some behind payments to it or something.
Have you previously worked at Excel Mulching?
Yes, ma'am. I've worked here on and off since 2013.
Okay, you've been back there for the last 90 days.
Yes, ma'am. My kind of work pipeline is just you start a job, and once it's over, you have to find another job. Might last a couple months.
This is where the hearing takes a dramatic turn. The judge begins reading the court order word for word, refusing to rely on anyone's interpretation, emotions, or assumptions. And honestly, that changes everything. Miss Smith tries explaining what she believed the order meant, but the judge immediately shuts that down, reminding everyone that the exact wording of a court order controls the case, not personal understanding. All right, guys, this is the brutal reality of family court. One badly written sentence can completely reshape years of financial obligations. As the judge continues reviewing the documents, he realizes the support technically ended the moment the oldest child graduated or turned 18. That means the father may not legally owe support for the younger child during a massive stretch of time. The courtroom tension instantly skyrockets because everyone suddenly understands the same horrifying truth. The legal paperwork itself may have accidentally erased years of child support obligations.
Let's see if you actually have that. Y'all be patient with me for just 1 second, okay?
Mm-hmm.
I got a court order signed by the judge on September the 11th of 2019. In this court order, it says that apparently there was some earlier custody issues between Mr. and Miss Smith and some third parties.
Yes, sir.
All right. So in this new custody issue from 2019,
The new custody.
that's okay, Miss Smith. I've got the paperwork right in front of me. Okay.
Yes, sir.
I don't. No offense. Your interpretation is not the same thing as me reading it specifically from the court order. Okay.
Yes, sir.
All right.
And there was also one titled Nunc of Prior Order. That was after that one.
All right. So there were two children in the court order, Gracie and Matthew. Miss Smith was named as the primary joint managed conservator. Mr. Smith was named as a possessory conservator. Amended order, it said that he was supposed to pay her $750 a month
Yes, Your Honor.
beginning October 1st. Okay. And the state has non-suited its request for modification.
Yes, because when we originally filed it, his wages were a lot lower, and now they've kind of gotten back to similar what it was in the prior order.
Okay. So based on what we just lost. Hold on, Mr. Smith. We lost Miss Smith. Of course, that would happen as soon as.
Now the confusion turns into outright shock. The judge carefully explains that although another child remained under 18, the court order was written so poorly that support legally terminated when the older daughter aged out. Listen carefully, because this is the moment the mother fully realizes what happened. She asks the question everybody watching is thinking, so he doesn't owe me child support after May 2021? And the judge delivers the devastating answer, legally, no. All right, guys, you can hear the frustration and disbelief pouring out of the courtroom. The judge openly admits the situation is unfair, but he also makes something crystal clear. Courts cannot rewrite history simply because an old order was badly drafted. The law only allows him to fix things moving forward. That's the brutal part. Even though everyone recognizes the mistake, even though the younger child still deserves support, the legal system is trapped by the exact wording used years earlier in that original court order.
Mr. Smith, when did Grace graduate from high school?
That's what I was going to tell you, Your Honor. In 2020, she's married now, and she's been living with her husband for 2 years. She lived with me at the end of 2019 for about 6 months.
Okay.
That's when she graduated.
That doesn't answer my question, Mr. Smith. When did Grace graduate from high school?
2020, I believe.
Okay. So that means her child support would have ended in October of 2020, even though she graduated 4 or 5 months before that. All right. So
We do need to
October of
modify.
2020.
And that was my question.
And unfortunately, your pay record is also incorrect, Ms. Hill Leonard, because your pay record continues this child support, which should have stopped on October the 30th of 2000.
This next section becomes a masterclass in courtroom reality. The judge patiently explains that he cannot magically recreate child support obligations that legally disappeared because of a defective order signed years ago. Meanwhile, financial records are introduced showing the father's recent income, average monthly earnings, and employment situation. The Attorney General's office pushes forward trying to repair the case through a new modification order, but the judge keeps returning to the same unavoidable issue. The original language destroyed the legal foundation for past support. All right, guys, this is where family court becomes absolutely unforgiving. Timing matters. Exact wording matters. Filing dates matter. The judge even explains that because the modification lawsuit was not properly served until late 2022, he cannot restart support retroactively before that point. And despite the emotional reactions in the courtroom, the judge refuses to ignore procedure or bend the law. He's trying to untangle years of confusion in real time, while both parents realize the consequences of a single legal drafting mistake.
I know that Grace aged out, but Matthew has not aged out.
I agree. It's not fair, but I can't change the court order in the past, Ms. Smith. All I can do is fix it from this point forward.
So August Muntsberry doesn't owe me anything.
He doesn't owe you anything from May. He doesn't owe you anything from June of 2021 until now. There was no child support ordered for that period of time. Okay? I didn't create the order, Miss Smith. I didn't write it and I didn't sign it. Somebody else did all those things. But that's clearly what the court order says. That's why we don't use any children in court orders. Yep, we don't do that any child stuff. Okay?
Yes, sir.
I don't agree with it, but I can't go back in time and fix it, Miss Smith. The law doesn't allow me to do that. All right. Miss Smith is here. Miss Hill Leonard, you can call your next witness.
Miss Smith?
Yes.
Just to make sure, you said that when did Grace graduate?
I don't know. She was born in 2002, so 21 probably is how that works. That's when, and it was in May when she graduated.
Okay.
You don't owe me nothing.
Now the hearing shifts into full legal analysis mode as the judge investigates whether the older daughter's homeschooling status affected the support timeline. And this part gets incredibly technical. The parents begin debating when she officially left public school, when she completed homeschooling, and whether that education program qualified as an accredited high school under state law. Listen carefully, because this detail becomes critical. The judge explains that homeschooling generally does not count as an accredited program capable of extending child support beyond age 18. That legal distinction becomes the final nail in the coffin for the mother's argument regarding back support. Alright guys, this is one of those moments where courtroom emotion collides headfirst with strict statutory law. The judge repeatedly tells both sides he understands the situation feels unfair, especially for the younger child who missed years of support coverage. But no matter how sympathetic the circumstances are, he cannot legally rewrite the past. He can only repair the situation moving forward from this point on.
Actual place in like Port Arthur or somewhere down there where I'm regioned at to go to the office, and they said I didn't have to do anything, and so I don't know. I'm just now getting emails to do this, so I don't know. I mean, I didn't even request this. Okay. So I don't know. What do you mean it's taken me so long?
Well, and this is a lawsuit, Ms. Smith, where the state of Texas the AG's office represents themselves. They don't represent either you or Mr. Smith. So yes, in a modification suit, I have the right to go back all the way back to the date the parties were served to start this child support again. Unfortunately, Ms. Smith, you were not served with this case until September the 28th of 2022. That means I can't start the child support again until October the 1st of 2022. How did you say that Matthew was covered for insurance, Ms. Smith?
Texas Medicaid.
Okay. And Mr. Smith, do you have any other children besides Matthew?
Grace and
that are still underage.
These are my only 3 children.
Oh. Anything further from the state?
I know, Your Honor.
Mr. Smith, is there anything else you think I need to know about this case before I make a ruling?
No, sir.
Okay. Ms. Smith, is there anything else that you think I need to know about this case before I make a ruling?
No, sir.
All right. Look, y'all, this is real complicated. You didn't make it complicated. It's not your fault. I didn't make it complicated. It's not my fault. The AG's office didn't make it complicated. It's not their fault. All right. There's a bad court order in this case from 2019 that needs to get fixed. And I'm going to fix that today. I wish I had the right to go back in time and fix it, because this child, Matthew, deserves support all the time. But I can't fix court orders back in time. I have to just fix them and keep moving. Okay? The law doesn't allow me to go back in time.
By the final ruling, the judge lays everything out with absolute clarity. Child support officially terminated back in 2020 under the flawed wording of the old order, and there is no legal pathway to recover the missing years afterward. However, the judge immediately restarts support moving forward, ordering the father to pay monthly child support, medical support, and small repayment amounts toward existing arrears. Alright guys, this ending feels less like victory and more like controlled damage repair after years of legal confusion. The judge openly says multiple times that he wishes he could go back in time and fix the broken order, but the law simply does not allow it. And honestly, that becomes the biggest lesson from this entire hearing. Family court is driven by exact language, precise filing dates, and strict procedural rules. One careless phrase buried in paperwork years earlier created a financial mess affecting everyone involved. In the end, the judge doesn't celebrate the ruling. He simply tries to stabilize a situation that should never have become this complicated in the first place.